As of right now, yes, sir, you are. You're being trespassed from the Winn-Dixie.
For suspicion of what crime am I being detained?
As of right now, you were videoing from across the street. That's what our call was about. And now that they want you trespassed, you're being detained.
Who wants me trespassed?
Winn-Dixie.
Winn-Dixie wants me trespassed.
It's a hot Florida day, and for licensed private investigator M. Hoffman, it begins like any other day on the job. Assigned to conduct discreet surveillance for a legitimate workers' compensation claim, he finds a legal, quiet location near the subject's home, a church parking lot with a clear vantage point across the street. By all legal standards, the situation is routine, unremarkable. But within moments, routine dissolves into confrontation. And what unfolds will challenge not only the understanding of legal boundaries, but the very nature of unchecked authority in modern law enforcement. This is not about misconduct buried in paperwork or years-long corruption scandals. This is about something far more everyday, and in many ways, more dangerous. A man parked legally, filming from a lawful position, carrying proper credentials, suddenly becomes the target of escalating police action. And as always, the camera doesn't lie. It begins with a call. Someone claims a man is watching kids with binoculars. The accusation hits hot-button nerves, children, suspicion, optics. The fact that it's unconfirmed is irrelevant. In law enforcement culture, perception often has more gravity than legality. A call like this demands a response. The problem? It also triggers a chain of assumptions that overrides constitutional protections almost immediately. Within minutes, multiple sheriff's deputies descend on the area. They circle Hoffman's vehicle, questioning his presence, his intentions, and, not subtly, his character. He's accused indirectly and then more directly of questionable behavior. Watching kids, being weird and suspicious. But here lies the first legal fracture. There is no reasonable, articulable suspicion that Hoffman was committing or about to commit a crime. That threshold matters greatly. Under Citing Terry v. Ohio, officers must meet a minimum of reasonable suspicion to detain someone legally. Mere presence in a parking lot with a camera, even a camera pointed in a controversial direction, is not a crime. Recording in public, including filming children in public spaces, is a protected First Amendment activity. It is uncomfortable for some, certainly, but it is not illegal. Still, Hoffman's situation deteriorates rapidly. At Katka Allen Paywag, he is questioned aggressively, asked for ID, and accused of failing to notify law enforcement. Officers assert that he should have called the sheriff's office to inform them of his investigative presence. There is no such requirement in Florida law for private investigators. This insistence is not a procedural error. It's an attempt to invent a standard and hold Hoffman accountable to it. And yet, Hoffman complies. He presents his investigator identification calmly, makes no sudden moves, engages respectfully, everything an officer could want from a detained individual. But still, their suspicion escalates. Not because of what he's doing, but how well he knows the law. This dynamic is incredibly important. The more Hoffman demonstrates a sound understanding of his rights, the more threatening he becomes to the deputies. After a few exchanges, he is physically surrounded by 4 deputies. Their tone shifts from inquiry to pressure, and one by one, legal lines begin to blur. The story offered to dispatch resurfaces. Reports of a man recording children outside a church. A pastor speaking with clear emotion recalls seeing Hoffman near the property and describes what they believe to be inappropriate behavior. To law enforcement, that emotional appeal becomes a basis of action. But there is no due diligence, no checking of camera footage, no investigation of the actual surveillance footage Hoffman was capturing. And so, the next legal violation begins to take shape: detainment without probable cause. Key point: even if a witness is uncomfortable, even if they report suspicion, officers are still required to perform independent evaluation of the facts before detaining a person. That doesn't happen here. The officers lean on the narrative from citizens, not evidence. Bite square. Hoffman raises the question of the Fourth Amendment. He hasn't been told he's being detained. No crime has been named. Yet he is being held in place, surrounded and monitored. Officers still refuse to identify a legal basis. And just as the temperature rises, a shift occurs. The response now centers on trespass, not surveillance, not voyeurism, but alleged illegal presence on private property. And here things become irreparably dangerous from a constitutional standpoint. The officers say they want to trespass him from the nearby church and the Winn-Dixie grocery. But under Florida statutes, for a trespass warning to be lawful, the person must first be asked to leave by an authorized agent and refuse. Hoffman had already left the initial property. He was now parked on a different lot entirely. There was no warning and no notice to leave. Yet a trespass citation was being prepared anyway. This is where probable cause is not just thin, it's evaporated. At Exfachat, we enter the high-tension moment that defines the case. An officer plainly tells Hoffman he is detained on the basis of a trespass complaint. "What crime am I suspected of?" Hoffman asks. There is no answer. The officer loops back to the report as if that complaint itself replaces legal standard with emotional echo. Hoffman, again composed, begins to cite the text of Florida's trespass code, word for word. The officer ignores it, speaking over him. This is not a debate. It is a power standoff, and Hoffman is winning it, not by shouting, but by knowing. Everything now hinges on this reality. Officers are not simply uninformed. They are actively asserting a power they do not have. They attempt to force a trespass warning where the legal elements haven't been met. They craft justification to match their intuition rather than source facts to match the law. Most citizens would collapse at this point, detained, boxed in, confused by overlapping accusations. But Hoffman refuses to collapse under pressure. Instead, he invokes something most people have never heard. Title 18, Section 242 of the U.S. Code. This is the federal statute that criminalizes the act of denying someone their constitutional rights under color of law. It is exceedingly rare to hear it invoked mid-stop, but Hoffman does, not as a threat, but as a legal anchor. Because if a law enforcement officer knowingly detains, searches, or punishes someone without lawful justification, they are not immune from prosecution. And yet, despite this bold, precise citation, no officer recalibrates. They either don't know the law, or they believe they are operating above it. This is where the systemic issue reveals itself. The issue is not merely about bad apples. It's about procedures that allow ignorance, ego, and public fear to outweigh legal obligations. To an outside observer, this can look like a misunderstanding. But to Hoffman, and to any law-abiding citizen confronted with unjustified authority, This is the breaking point of American civil liberty. The irony, of course, is that had Hoffman not known the law, this encounter would have ended much bleaker. He may have been charged, his equipment possibly seized, his license challenged, his public image distorted. But knowledge, composed posture, and the presence of body cams create a triad of defense that repels institutional misuse, at least momentarily. In Part 2, we'll explore how this situation breaks down, not just from a single incident, but from a broader systemic failure, where institutional mechanisms encourage power expansion, silence accountability, and allow vague suspicions to override the very rights they are sworn to protect. Continuing the structured breakdown. As the confrontation between Hoffman and law enforcement expands in physical size and administrative complexity, a second, quieter battle begins. Not on the streets, but within the legal framework that underpins every decision made by the responding deputies. Here, in Part 2, we uncover how misunderstandings, misinformation, and unchallenged assumptions create the ideal conditions for constitutional overreach. And more importantly, how law enforcement's relationship with public fear often trumps their adherence to the law. Let's start with positional authority. By timestamp, by Fasaivari, the lead deputy asserts that because Hoffman is near a church where children were playing, and because someone allegedly saw him filming or using binoculars nearby, he should have known to notify police of his presence. While it may sound like common sense caution for a private investigator to alert authorities, the law in Florida imposes no such requirement. There is no statute requiring a licensed PI to notify or coordinate with law enforcement unless their activities cross into restricted conduct, such as impersonating an officer or violating privacy laws. What we see here is the emergence of an unofficial rule, one that enforcement officers impose but cannot codify. It's an expectation rooted not in statute but in discomfort. The logic is simple. If something makes the officers uneasy, or if it triggers alarm in the public, then the subject should have, somehow, anticipated that discomfort and proactively absorbed the burden of correcting it. But that's not how law works. The Constitution protects lawful acts even when they offend or unsettle. And this is where things become dangerous. By timestamp 6. A new tactic begins to surface, the strategy of retrofitting probable cause. Now that Hoffman has identified himself, presented legally valid documentation, and is clearly not breaking any laws, the officers shift gears and begin fishing for alternative legal justifications. They begin speaking with business owners, asking if they want Hoffman trespassed. One officer asks whether he had permission to be parked on the property. The answer? He's on private property, but hasn't caused any disturbance and wasn't asked to leave before police arrived. Again, this matters greatly. Under WITI Florida Statute 8.10.09, in order to issue a valid trespass warning, officers must first establish 1. That the person was on private property without authorization. 2. That they were asked to leave by the lawful owner or agent. 3. That they refused to comply. None of those requirements are met here. Hoffman had already left the first property, the church, and is now parked legally at the Winn-Dixie lot. Yet despite no complaints from staff and no prior warning, officers pressure the employees until they agree to issue a trespass notice. One deputy, speaking to a store representative, casually frames the question as, "Do you want him trespassed?" This framing is not neutral, It functions as a leading question. The employee, likely unfamiliar with civil litigation or liability, quickly agrees. Whether they understand the implications or feel intimidated into compliance is unclear. Regardless, what follows is police-induced trespass, a tactic increasingly seen in bodycam audits across the country. Law enforcement leverages their authority to manufacture a basis for exclusion, relying on the willingness of business owners to comply almost reflexively. And it's effective. A legal foothold is retroactively created, one that superficially legitimizes detainment and keeps the civilian outnumbered and off balance. Back at the site, Hoffman is still being held. As he challenges them on the legal requirements of a trespass warning, particularly the necessity of being told to leave before being penalized, the deputies offer no legal clarification. Instead, they double down on vagueness. "You're being detained because of the report we got," one says, while another cites public safety. These aren't statutes. They are narrative shields. Broad-stroke rationales designed to resist legal scrutiny with emotionally charged framing. Kids, churches, binoculars. This misuse of generalized safety language is a core theme. It taps into the public's deepest fears and uses them to short-circuit the legal analysis. After all, who would want to nitpick constitutional law if there's even the slightest risk that children were in danger? But what happens when those justifications are exploited in the absence of actual threat? Here we see real-time abuse of what could be termed the safety pretext. This occurs when officers invoke safety terms such as "for the children," "for the safety of the community," or preventative action to mask the absence of actionable proof. And while such language may survive public relations scrutiny, it poses a direct challenge to civil liberty when deployed on the street. By timestamp 7:50, with no crime committed and no justified reason to detain, Hoffman is handed not one, but two trespass warnings. One from the church and another from the grocery store, neither of which followed proper procedure. And when he presses for clarity, "What crime am I being suspected of?" the officers stutter. One officer admits that trespass is the only viable charge since they want him gone. What we are witnessing here is textbook mission drift. The quiet shift of police objectives from investigating a report to ensuring submission, even if that requires distorting what constitutes an offense. When Hoffman brings up in Title 18, Section 242 TN, the tension spikes. Here's why it hits so hard. This federal statute was established to prosecute officials, including law enforcement, who willfully deprive a person of rights protected by the Constitution. This means unlawful arrest, detention, or intimidation can carry criminal penalties, including up to a year in federal prison or 10 years if physical force is involved. The officers don't acknowledge the statute, they avoid it. Their tone changes, not because they're responding to education, but because they're unsure how to react when a civilian starts calling out federal statutes on record. And that's where Hoffman's composure compounds its power. He isn't yelling, he doesn't storm off. Instead, he relies on the weight of law, a calm but unrelenting resistance rooted in statutory precision. At timestamp 9, we see renewed tension. Hoffman asks directly to speak to a supervisor. The request is ignored. Instead, officers begin insisting he leave. He clarifies again that he's been detained, not free to go. Now the contradiction is overt. He's being told to leave, but also being detained for not having yet left. The circular logic betrays the transparency of the real goal: compliance, not justice. This contradiction reveals the systemic fragility of the encounter. Officers are neither obeying the procedural steps nor offering a lawful path to resolution. They just want it over. Rapid power recovery, no investigation, no reflection. Just a decisive end, sealed with a boot on the ground, bureaucratic stamp of, "You've been officially trespassed." A punishment without a crime. As they push him off the property, denying any wrongdoing while doing everything wrong, Hoffman's voice finally carries more edge. He calls it what it is: an abuse of power. Not a miscommunication, not overzealous concern, straight power flex. It's an accusation with resonance, because the evidence is in the tape. From the first call to the last minute of the interaction, not once do law enforcement invoke the investigator's rights. Not once do they question whether he remained within legal boundaries. They assess optics, they assess liability, they do not assess law. And this is the greater rot exposed. When an officer's priority becomes finishing the interaction instead of justifying it, due process is a casualty. Hoffman is eventually let go, but the damage is lasting. He is now banned from a business without having committed a crime. His reputation is at risk. His professional tools, legally utilized, have been tainted in the eyes of the community. And all of this unfolded because officers didn't want to step back, review the law, and admit the absence of legal grounds. In Part 3, we move towards systemic implications. How did this institutional culture take root? What mechanisms allow authority figures to condense public fear into legal-sounding judgments? And what must be done to ensure that law enforcement lives within the same laws they're sworn to uphold? The most telling moment in this case isn't found in raised voices or physical force. It's in what happens afterward, the confrontation. The paperwork is written. The trespass warning is issued. M. Hoffman, still calm despite a 30-minute detainment with no stated legal basis, quietly departs. No charges were filed. No rights formally read. No arrest occurred. On paper, it's a non-event. But beneath that surface lies a far more disturbing truth. Power was exercised, rights were strained, and not one officer was held accountable. This is the most dangerous kind of violation, the one with no bruises. Because if you look at many civil rights cases, the ones involving excessive force, false arrest, or fatal outcomes, they don't begin with chaos. They begin here, with suspicion, thin legal ground, and an officer unwilling to be challenged. Let's revisit the closing exchanges between Hoffman and officers, beginning around Gers, Psych timestamp 11. Hoffman asserts that he has broken no law, a claim substantiated by the Bodycam footage itself. He challenges the authority of the officers to demand compliance with a trespass order that doesn't legally apply. Instead of countering his points with statute or regulation, the deputies sigh, dismiss his legal reasoning, and label his behavior as irrational. It's a critical pattern to observe. In law enforcement encounters, asserting your rights is often framed not as lawful resistance, but problematic behavior. This psychological flip, where calm legal advocacy is reinterpreted as aggression, is part of a broader institutional pattern. Officers are trained to read body language, tone, and perceived non-compliance as threats. But in many departments, especially those lacking regular constitutional training, the threat includes knowledge, and that exposes a core flaw. Because if authority is destabilized not by violence, but by legality, it was never lawful to begin with. Consider again how the officers secured compliance from the Winn-Dixie manager. They didn't observe misconduct. They didn't receive a genuine complaint from the store itself. Instead, a deputy approached and asked whether, given the circumstances, they'd like him trespassed. Now think through the implications of that scene. A police officer in uniform approaches a business owner or employee. The officer references reports of odd or suspicious behavior. The implication is that this customer or visitor is a problem. In that moment, most civilians, unfamiliar with criminal liability, deeply respectful or fearful of law enforcement, will say yes, whether to avoid risk, conflict, or just to move on. This is not a free choice. It's coerced consent, and it allows law enforcement to insulate their unnatural use of authority inside a civilian decision, sidestepping legal boundaries entirely. This pattern is not unique to this case. Civil auditors and legal observers across the country have documented dozens of similar situations. Someone filming in public legally is questioned, pressured, and then trespassed, based not on law but on the social leverage police exert on surrounding institutions. And once that trespass order is issued, the switch flips. Suddenly, police have grounds for physical removal or arrest if the person fails to comply. What began as a legal activity is reframed post-fact as a lawful trespass action. It's a manufactured offense dressed in the illusion of public order. Adder timestamp 13N. The facade drops entirely. Hoffman, now simply trying to leave the parking lot, is still being hemmed in by officers. He again asserts that he's been unlawfully detained and that his rights have been violated. A deputy shrugs him off. "You're not being detained," the officer says, after holding Hoffman on site for over 30 minutes without letting him drive away. It's insulting and telling. Legally speaking, Hoffman's status is clear. He was detained, even if not arrested. He was held against his will, not free to go, while being questioned and issued documents under threat of further legal action. Denying this reality only highlights how fragile and reactive the enforcement posture had become. And here's where the long-term consequences begin. Because this was a zero-crime encounter. No law was broken. And yet, legal tools, detainment, threats of trespass, heavy police presence, were deployed against a credentialed investigator performing a legal duty. If this level of forceful presence can be summoned so quickly over a complaint without vetting, what does that mean for the broader public? The answer is unsettling. Anyone who triggers discomfort becomes a suspect. Wearing a camera, driving a certain car, standing in a parking lot too long, being seen holding binoculars, these acts are all lawful. But they are also, and in the eyes of police and some citizens, odd. And in today's culture of empowered suspicion, odd is all it takes. So where is the protection? Ironically, it's in the very statutes Hoffman tried to invoke mid-stop, and especially Title 18, Section 242 of the U.S. Code. This landmark federal law was created to prevent officers from manipulating or abusing their power under the color of law. The idea that with a badge, any command becomes justified. That federal law just specifically criminalizes the act of depriving a person of their rights, whether free speech, Fourth Amendment protection, freedom from unlawful detainment, or equal access to public spaces. And it's rarely enforced. Why? Because accountability is institutional. Complaints go through the department. The body reviewing misconduct often consists of colleagues, and bad behavior, unless egregiously violent or caught on viral video, rarely makes it past internal review. But here, we have something rare. A Bodycam interaction that exposes procedural misconduct without a single punch thrown, shot fired, or weapon drawn. This is pure passive suppression, and it's harder for the public to recognize, let alone protest, because it rests in tone, implication, and manipulation of legal process. Even the closing comments from officers betray an unease with challenge. One implies Hoffman licks boots like the uneducated, a defensive deflection. Another accuses him of acting irrational, angry, edgy. Hoffman responds, "I'm upset you're abusing your power." And in that line, we reach the heart of this case. Because abuse of power in 2026 doesn't always mean fire hoses and handcuffs. It often looks like this: manufactured trespass orders, stonewalled questioning, legal silence under pressure, emotional appeals over procedural law. It's calm, it's controlled, and it's completely unconstitutional. So what now? Hoffman's departure, filmed, frustrated, but unbroken, leaves us with more than an ending. It leaves a template. A guide for public defense. 1. Know your state statutes, especially trespass, detainment, and First Amendment protections. 2. Carry identification and training documents if your job brings legal scrutiny. 3. Always ask, "Am I being detained?" 4. Record everything. Body cams are only half the equation. 5. Learn the language of challenge, not escalation. Calm assertion backed by law is more effective than shouting. But most importantly, recognize the shift in modern policing. We're entering an age of subtle overreach, not crackdowns, but encroachments. Every civic right becomes negotiable if the public forgets the laws designed to protect them. Hoffman stood firm at just the ear, and in doing so, exposed a system not prepared to be questioned. His case reveals how everyday authority functions when left unsupervised, and how the quiet distortion of legal language enables officers to do what the law never intended: convert discomfort into justification, suspicion into control, and compliance into a public expectation. This is the future of fights for civil liberty, not courtroom drama or protest lines, but sidewalks, church lots, grocery store parking spaces, moments that seem minor until the law is pushed just far enough to break. We'll end on this sobering reflection. If Hoffman hadn't known the law, he'd have likely been arrested, charged, and silenced, held up as just another suspicious man in a parking lot with binoculars. But because he knew, because he stood firm, because he didn't yield to vague threats, we now have proof on camera that the badge alone is not the law. The law is the law, and no amount of pressure, posture, or polite tones can bend that, unless we let them.